Alright, this We the People News, one more time at it. Alright, educational purposes only. Okay, not attorney, not giving legal advice. Alright, never look straight forward, always look around and be able to protect yourself by any means necessary. Alright, arm yourself with knowledge. People use that Second Amendment. Now, I apologize for the other video being a little short. I forgot to clear my space. It happens. But I want to stretch it out a little further so we don't interrupt this video no more than I have to, right? This is the reason why in my previous video, all right, the victim, and the witness, victim and witness, okay, must sign an affidavit under penalty of perjury, okay, and all that. They're filing a claim against you, okay? The officer's still just hearsay. He's not even a witness. He's just a witness to hearsay if the other party, the claimant, is not going to sign an affidavit. They directly are just hearsay. So they must go down, file a claim under penalty of perjury to be actual, real, certified. But, you know, they do what they do, right? Let's go.
The crime, and if you were present and you are personally bringing the accusation, then that means that the state is bringing the accusation and the state is a party in the cause. Either way, we defeat them on this issue, but nonetheless, these warrants are not valid because they're not supported by oath or affirmation, because the person that needs to give the oath, right, needs to sign under penalty of perjury is the witness, not the officer. The officer doesn't get to sign because he wasn't a witness. Okay? My affidavits, however, that's why I'm traveling the country, that's why I'm meeting with all of you, that's why I'm getting you to sign these affidavits, is because you are the witness, not me. I'm simply the evidence custodian. You guys had the crime committed in your presence. Therefore, you are signing under penalty of perjury that this information is truthful, factual, and correct. Not me. I would be...
I'm going to interrupt that as well. Right, okay. So, side note. So, when an officer issues you a ticket, which comes with a fine, he created a bond. Okay? But, with that bond in the corporation party, he cannot be a witness. So, the ticket itself, the officer cannot be a witness because it's a bond. That would be fraud under the Debt Collection Agency Act and all that kind of stuff, right? So, just saying. It nitpicks a little bit more than that, but just that in general itself is conflict of interest with that officer.
Officer in their scenario. I'm taking your information that you are declaring under penalty of perjury, that the following information is factual, truthful, and correct, and I am personally taking it and delivering it to the judicial proceeding as the evidence custodian. That's what these affidavits are about, right? I am the...
I remember when I told you guys a while back that you can actually go to the magistrate and have the magistrate issue these warrants, even against a cop, even against your sheriffs. Now, will they do it? Yeah, you know how that goes, right? They got to protect their own, all right? The only one that's getting violated is we the people, because they all protect each other. We don't protect one another is the issue. There's 365 million of us, and 10,000 or maybe 10 million overall government officials. Are you telling me they have enough power to take we the people over? Sit and think about that. How do they control that many people? They make us and feed us so full of lies that we argue amongst one another while the judge protects the cops protect the judge, the attorneys protect the judge, the attorney protects the cops. Everybody's protecting one another in the government body itself. But nobody's there to protect you, not even your fellow man. They want to argue with you. I said, well, you should have done this. You should have bowed down to the almighty gods. Don't get me started. Let me start again.
Custodian, I am the officer. I'm not declaring that the following information is truthful, factual, and correct. You are. You guys are the victims, not me. Our affidavits are valid. Their affidavits are as the evidence custodian. That's what these affidavits. Not me. I would be the officer in their scenario. I'm taking your information that you are declaring under penalty of perjury that the following information is factual, truthful, and correct, and I am personally taking it and delivering it to the judicial proceeding as the evidence custodian. That's what these affidavits are about, right? I am the evidence custodian. I am the officer. I'm not declaring that the following information is truthful, factual, and correct. You are. You guys are the victims, not me. Our affidavits are valid. Their affidavits are a violation of the Fourth Amendment. What happens with information? I want to run through this one more time here, right? Because what happens with information is that someone calls up the police and they say that something happened to them. So the police come out and collect the information from the accuser. That officer then reduces that information into writing in the form of an affidavit. And then that officer declares that the following information is truthful, factual, and correct, and brings it to a judge. That judge then reviews it based upon a single set of facts, not the other side of the story, but a single set of facts, and says, yes, I have determined that there's sufficient probable cause to assume that a crime has been committed, and then he orders your holding and arrest to be held over for that infamous crime or capital crime, whatever it might be. The judge is making that decision, right? The judge is. Now
remember, when the victim is, okay, educational purposes out there, okay, not attorney, yeah, not giving legal advice. But when you are been a victim, you need to provide the officer evidence as well, all right, of some form, whether somebody's there or, you know, they damaged it, here's where the damage is, at least some form of evidence to give some type of standing, okay? Because we know how, if you watch these videos, you know how they lie. Oh, by the way, the Fifth Circuit says it's okay for prosecutors to lie to the grand jury. Okay? Because they got qualified immunity. And the number one lie, to indict people with like a ham sandwich, is the word intent. Okay? Educational purposes.
this sets up what is known as a trial by affidavit. Trial by affidavit. Trial by affidavit was our founders' one of their greatest concerns because they themselves were being prosecuted by trials by affidavit, right? That's why Thomas Jefferson wrote in the Declaration of Independence that in many cases we have been denied the right to a trial by jury because they were being tried by affidavits, right? That's why he stated in the Declaration of Independence that we have been subjected to a jurisdiction foreign to our laws because the king back in 1628 had shifted the colonies into the admiralty jurisdiction and not common law jurisdiction. Therefore, it was military tribunals. It was the judge acting as both judge and jury in the sham process back then. That's why they created the grand jury. That's the purpose of the grand jury, right? So when you have a trial by affidavit, it is what is known as an irrebuttable presumption of guilt. Irrebuttable presumption of guilt. Now, an irrebuttable presumption of guilt is the presumption that you are guilty based upon the mere fact of being charged with a crime. So if you are presumed to be guilty based upon a charge, then what they'll do is they'll come and arrest you. And they'll start depriving you of your liberty immediately, right? they'll put you into jail, right? This is called a pre-conviction detainment.
And because you cannot rebut it, well, you're in silence of acquiescence. So therefore, you have tacitly agreed to the terms that you are a criminal. Now you got to go back through the process, what he's just fixing to say. But I was doing a little bit more clarification on this. Now you got to kind of go back in there and go through court and actually stand trial and rebut the thing you did not get to rebut before and do rebuttal. And you try to get yourself out of that silence of acquiescence and try to get yourself out of that tacit agreement that you was forced into.
Detain you in this jail where you will be denied all of your fundamental rights, such as your right to earn money, to take care of your family, to use your property, to be free, right? All of these things are taken away from you because you are presumed to be guilty based upon the mere fact of being charged with a crime. Okay? Now, an irrebuttable presumption of guilt is, remember, if you don't have an opportunity to rebut an accusation, then in common law, that accusation becomes truth. So the moment that the officer submits to the court the following information is factual, truthful, and correct, right?
Correction. He said truth. Well, truth is broad. So according to courts, it would be true. Okay? So you got to go back and clean that back up, which now you're no longer presumed innocent. You got to prove your innocence. Everybody knows nowadays that you're presumed guilty. Okay? And they don't know why. Well, this is why, right here.
Then that information has now not been rebutted by you, the accused, and now it becomes truth. The Supreme Court has long determined, and Blackstone has long determined, that if you are tried by an affidavit, that your right to confront your accuser evaporates, right? It evaporates because you can't put that information on the stand and cross-examine it because it's truth. It's unrebutted. And if you don't have the opportunity to rebut the accusation, the affidavit, then you are now believed or presumed to be guilty based upon the mere fact of being charged with that crime. So now what happens with the irrebuttable presumption of guilt is that, again, you are presumed guilty based upon the mere fact of being charged with the crime. Your liberties are being deprived based upon a single set of information, and you are treated as though you're guilty. Now, what happens then is that you, as the accused, you have to go out and collect evidence in order to prove that you're innocent, right? Right? You have to prove that you're innocent because it's a shift in the burden of proof, okay? Now, the way that the system's supposed to work is that the prosecutor has to prove that you are guilty beyond a reasonable doubt. Right? That's the burden of proof. That's what we all believe because that's the way the system is supposed to work. But when you have an irrebuttable presumption of guilt, the burden of proof shifts from the prosecutor onto the defendant. Now the defendant has to prove that he's innocent because of the mere fact that he was charged with a crime. That's why investigative detainments have always, up until September 11th, always been unconstitutional under our system of legal philosophy, right? You cannot detain someone and hold them over in an institution where you deprive them of their liberties without finding them guilty simply so that you can create a certain amount of pressure to threaten, intimidate, coerce, or duress someone into entering into a contract of guilt with you because you don't want to take the time to actually follow the fucking rules, state.
All right, we're going to stop right there. Does this actually starting to make a little bit more sense to some of y'all? All right? Does it really? Remember, I told you before on the last video, you got to open your mind. You cannot use that cognitive dissonance. All right? You really do got to open your mind and do a reboot of your thinking. Okay? And I understand there's a lot there, but really, Does that more sound like the way he's talking, the correct way of doing things? When it's said and done with? Just saying. That's your decision. Alright, see you in the next one. This Way the People News. Bye, y'all.